We are excited to offer probate services to families in Nichols Hills, Oklahoma. A majority of probates are administered in long form, and they take several months and even years if the parties are not agreeing with each other. For lack of a better word, I call these regular probate proceedings. The attorneys will first determine if there is a last will, a pour-over will, or nothing at all. If the decedent died without a last will, this is called dying intestate. If the client agrees with the wording, then the law firm will have them sign the petition and they will file that petition for probate with the court clerk. The judge will order that the petition will be heard at some future date, usually at least 30 days in the future. Probate lawyers will publish notice of that hearing in a local newspaper and will mail a copy of the notice of hearing to all interested parties. This is usually done by certified mail so we can prove that they got it and that we attempted to mail it to them. At the first hearing, the court will usually make 4 determinations. Number 1, does the district court have jurisdiction to hear that matter? So if we're in Nichols Hills, Oklahoma, does the Oklahoma County District Court have jurisdiction to hear a probate proceeding for a family that lived in Nichols Hills? If the decedent did not live in or have assets in that county, then the court might not have jurisdiction. If your loved one had a house and lived in the county, then that county, where Nichols Hills is, Oklahoma County, probably, most likely, has jurisdiction. Number 2, is there a valid last will and testament that should be admitted into the probate? In other words, will the court accept that will and use it as its guide during the probate process? The executor or personal representative is usually a family member and is the person who hired the probate attorneys to file the probate petition, the petition for probate. Number 4, who are the legal heirs, sometimes called the beneficiaries of the estate? The judge will actually issue an order at that first hearing stating exactly who the legal heirs are. This is important because these legal heirs now have the legal authority to consent to the sale of real property, real estate, that belongs to the estate. It is also helpful to know whether the estate is going to be split 4 ways, 3 ways, or 18 ways, right? Once the court has made those 4 determinations, it will usually appoint the petitioner as the personal representative. A personal representative, sometimes called an executor, like I said earlier, depending on where you live. This personal representative is charged with administering the estate of the decedent, of your loved one. This involves gathering and identifying all assets, settling claims, administering the estate, and finally distributing what is left over to the heirs. Depending on your state, creditors usually have 60 days from the filing of the notice to creditors to file a claim against the estate. The notice to creditors is published in a local newspaper in the county where the probate is being administered. Notice to creditors is also mailed to all known creditors of your loved one, usually by certified mail. If a creditor files a claim against the estate, then the personal representative decides if it is valid and should it be paid. That claim must be approved by the court before any payment can be made. A general inventory is required to list all of the estate's assets. This list usually includes what is in the estate, such as personal property, mineral interests, financial accounts, real estate. When the real estate or personal property needs to be sold to satisfy debts or to make money available for distribution, the personal representative will make an application to the court for authority to sell those assets. Again, the judge must approve this. Earlier, I stated that the court determines the legal heirs of the estate at the initial hearing on the petition. Because the judge made that determination, all of the beneficiaries have the legal authority to consent to the sale of the real estate or personal items by the personal representative. They have to give the personal representative their consent. If they do, then the personal representative usually sells the house with a realtor and deposits the proceeds into the estate bank account. This is a separate estate bank account, not the bank account your loved one had during their lifetime. Once the personal representative has gathered all of the assets, paid and settled all claims, then and only then is the estate ready for distribution. This is usually done by a final account, and you guessed it, another pleading and another notice. Notice of that hearing for final account is published in the newspaper, mailed to all interested party by certified mail, and usually set sometime in the future, usually about 30 days. As you can see, if everything goes perfect, a probate will take 4 to 5 months. They never go perfect, and they usually last 5 to 7 months If the family starts fighting, then we have had that happen on a regular basis where the family just can't get along, and it takes years because it's hard to get onto a judge's schedule. So the best thing that you can do is to get along with your family and get the probate done as quickly as possible. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.